Hi, and welcome to Beyond the Gavel. And this time I'm talking about something very, very special. That is Peyton AI, which is due to be released very shortly. Now, the first thing I want to do is ask you a question just to think about to yourself as a lawyer. How many times in the last couple of years have you actually taken on something and you wish that you'd never seen it? Because by the time you have got your medical evidence, by the time all your work has been put into it, and you suddenly find that economically you've been overtaken, it's not going to succeed, if at all, to the extent that you really thought. Now, one of the big things there was the bottleneck. It was not knowing right up front whether you had a case or not, or whether it was likely to succeed at a decent level. And that's really where we started. I was that bottleneck. I have 40 years of doing this and looking at medical malpractice and looking at the features that we need to know, and became skilled at doing the screening. But I was that bottleneck. The lawyer had to wait for me to come back, and that was taking up their time and their billable hours. For me, at that time, I really didn't know any better until I met a gentleman you're going to meet right now, Jesse Toprak. Because the question wasn't really whether it was going to stop with me, but whether AI could actually take on the thought process of a medical expert, somebody who knows what they're doing, and translate that into a method whereby others can use it and use that judgment. Not the facts of the case, but the judgment on those facts. And that's where Jesse came in. When we started to have this conversation, Jesse pointed out to me that that was a feasible thing to do. And that's where this all started. So let's hear from my friend Jesse about how we met and how he sees this starting to develop.
Hi, Rodney. Thanks for having me. I appreciate it. This is very exciting for me, both at a personal and professional level. We met, I guess, over a year ago now in a completely different project. I've been working on tech startups within the automotive field for almost 30 years and solving a lot of complex problems where the focus is processing and analyzing mountains of data to produce actionable intelligence for the leaders in the automotive world. And when we start discussing about your background, what you've done, first off, I was completely impressed and starstruck because the intersection of medicine and law is something I was always interested in, but just did not have a chance to deep dive previously. And when you were talking about the challenges that are being faced in the medical legal industry, it was almost like a light bulb moment for me in terms of what we can do. And I believe what it is it comes down to pattern recognition. In the car industry, a micro defect in a supply chain, for example, can recall a million vehicles. In medicine, a subtle deviation from the standard of care can alter a patient's life forever. Both fields are massive, complex systems where a single error changes everything. So what you and I realized, I think at the time, is that law firms are drowning, trying to find out that one specific error manually. So what we ended up doing is we brought the predictive precision of automotive engineering into the medical legal world so firms can spot the winner and weed out the loser in minutes.
And your expertise was so vital in that because, my background has been in education with the College of Surgeons and bringing in education. And there's the Peyton four-stage technique, which is widely known about how you train surgeons. And it was about taking an expert's knowledge, about breaking it down, about getting someone else to understand that breakdown, to be able to build them up and put it together again, and then to keep strong touch and then lighter touches, with a human in the loop, if you like, until they could fly on their own. And it dawned on, I think you and I at the same time, that AI is the same process. Could we use AI to download, expertise? And by doing that, could we set up a system where AI would learn, be overseen in their reasoning, not just the facts of the case? Anybody can pull those, and we'll talk about that later when we talk about general AI. But specifically what we do, if it could understand that process. Because the difficulty is, any lawyer here will know that does medical malpractice that at least 90% of the cases that walk into the door have no legs. Now, they don't know that lawyers are not doctors and they don't know that. Some they may have seen before and be very obvious, but a lot of them aren't. And so they're left with looking for that expert right up front. And also they want to go through notes. So they will get sheets of notes. Now, when I started this, you had about maybe 20, 30 pages. Now you have literally thousands of pages of notes. Some of them have been through AI anyway. And you have all that record to be read. And for an expert having to do that without any help is bad enough. But for a lawyer to have to do that, it's killing. So what did you see in the car industry about this avalanche of knowledge that people need to have? And how did you sort it out? Because you just tell everybody what your experience in the car industry is and how you
Mhm.
saw this in your life.
Well, I started out actually at the retail end, understanding how the retail works, how people buy cars, why do they buy cars. But then I started with tech startups, as I mentioned. The idea here is to gather all of the data available that we can get our hands onto about car buying, selling, and analyze them, and then come up with reports that can guide the industry leaders to make better decisions. And it was similar in a way at a time where AI didn't exist at a shape that is nowhere near where it is now, where we're using manual calculation methodologies. If I had the tools that we have available today, 10, 15 years ago, would have been a whole different landscape. I had to have, for example, just to analyze automotive industry data, a team of 40 analysts with 5 PhDs to go through what maybe one AI program can get through in an afternoon by itself. So those massive tools that are available to us now that are powerful. When I looked at the shortcomings of the industry, medical legal industry, it's if you look at, for example, think about the sheer emotional and financial drain on a firm where a brilliant associate who spends 3 weeks digging through an intake file only to find out there's no case. It's an incredibly expensive tax to pay just to say no to a client. So what we want to do is based on what I've done in the automotive industry in terms of looking at mountains of data, coming up with the gist of it. What is the action plan out of this? We want to give firms a way to get to that no in 5 minutes, that so that they can spend 100% of their time and energy and time and capital on the 5% of cases that actually matter.
And that translates into billable hours. And of course, the other thing you're pointing out with this avalanche, if you don't know what you don't know, then there could be all sorts of records missing.
Mm.
The important things, and I mean, we've embedded that in the thing to know what critical bits are missing that you need to go and find out, or have you got all the pieces you need? Because we've got to get to the stage of getting what we call the merit score. And the merit score looks at when we overview what the case is with the evidence that's given to us, both
Mm.
from the statement of the client and from the records available. We have to look at, a duty of care, is it there? Whether that standard is breached. And what's interesting to me is that you could tell me, listen, Rodney, it doesn't matter. I can look at that in Australia, United States, Canada, Europe, UK. We can look at each jurisdiction, and even within the states, you can look at jurisdictions
Mhm.
in each state and
Yes.
find out what the standard of care was. And that AI can do. And then knowing what's missing and putting that together, we can start to look deeply at that as opposed to horizontally to find out whether there is such a case. Now, the important thing from yours was finding that critical bit that's missing and what the damages were. But also, there's a lot more in it than that, that you are looking to see this merit score. Now, that's something you came up with and we worked on together. Tell us a bit about the merit score, where your thinking was and how that's come into being.
I think there are a couple of reasons why we had to come up with a consistent numerical number across law firms, across nations, to help law firms figure out what the case is worth to them, their time and investment. So how do we do that? If you look at the industry from as an outsider that came in early on, the biggest hidden risk, I think, in a law firm isn't a lack of talent. It's consistency. It's not having the consistency. One partner looks at a file and sees a winner, and then associate looks at it and it's not sure. So we just wanted to create a universal baseline that makes sense and it standardizes medical malpractice cases in terms of the worthiness of pursuing. A merit score is not a prediction of success. It's important to note. Even with a high merit score, as we defined, and based on, again, four pillars of medical malpractice, was a proprietary formula that we basically were able to put together based on analyzing thousands of cases that you were part of and understanding the flow of those cases, the ingredients of the cases, and what ended up happening. We're able to emulate real life cases into a formula that now becomes a predictive tool for the worthiness of it. You may have a case with a high merit score, it still may not succeed. So there's no guarantee on this. But what we want to do is, it's not so merit score is not some black box magic trick. It's just a common language. It allows everyone in the firm, from the founding partner to the newest paralegal, to look at a case file and instantly know where they stand on the likelihood of success so that they can figure out whether they should be spending their time with this one or not.
And it's worth those billable hours to do it. Isn't that what it's about? And the other thing is the merit score can change. If you get more information, the way you've built this, Jesse, is you can actually put that extra information in and run it again in seconds. I mean, it's the speed, isn't it, that you can do these things in? Tell us how the speed has evolved.
It's incredible. Yeah. So maybe a bit of a background about how the system actually works might be helpful so that it makes sense as to the flow and how we actually do these calculations. So what we do is that we've gathered all the information we can for all the jurisdictions we operate in, and currently it's going to be all 50 states in US, all EU nations, and Australia and Canada and UK. For all these jurisdictions, we have gathered all known standard of medical care database, always updated on a daily basis. Same with the case law specific to that each jurisdiction, again updated on a daily basis. We then took and analyzed over 5,000 cases that you yourself have been a part of in an anonymized fashion. So this is a custom LLM build-up in a way where the way it works is cases come in, and it could be 5,000 pages, 8,000 pages. As you know, we've dealt with some cases. We just processed one about a month ago that was 8,000 pages of records. And this was a combination of very hard to read, for me it's impossible to read, handwritten doctor's notes.
No, handwritten notes from a doctor. How terrible.
I know, I still can't do it. I don't know how you guys make any sense out of them. But good news is our system is
It's a
able to. So
secret code.
that's right. Must be, exclude the commoners out of the whole thing, right? Um, but we figured out an LCR system that actually can read this quite accurately. We can always, of course, electronic medical records is easy, it's all digital. We also have been able to integrate DICOM, which is the raw format for medical imaging, from X-rays to MRIs, etc., where you can simply drop the raw files into your case upload screen, and our system is able to read all of these imaging. And if there is already an existing report from a specialist about these imaging series, we will compare our analyses to that of the experts to see if there's any discrepancies. And if there's no expert report about the series, the imagery series, we can create one so that there's some substance to go by. And then you can just drop zip files in it. You don't even have to extract these files. So the whole idea is that how can we make this as easy as possible for a law firm or anybody who wants to use this? And this can be utilized by hospitals, insurance companies. And also, it's important to note that the tool is available to all parties involved in the medical malpractice world.
So plaintiff and defense.
Exactly. So defense can use this just the same way, probably I will argue even more strongly in terms
Yeah,
of
because they've
the
got records
claims
from
section.
and reports. Yeah.
Precisely. And then there's other tools that we have available we can talk about, like our sidebar, chat bar, simulation engine, all that. It applies to everybody. It's also an amazing tool for training young attorneys. So we're planning to work with law schools to offer this tool because you get to practice, their strategy before when you start dealing with the case. But so going back to the system architecture, so the system, to make it as simple as possible, knows everything there is to be known about the medical malpractice cases in the jurisdiction, about standard medical care and case law. And then it taps into the custom LLM that was created through your works on the 5,000 plus cases that we were able to analyze. So that enabled us, the database of the anonymized cases that we've worked on in the past gave us this incredible mode where it helped in two fronts. When we were working on the merit score to begin with, It gives us definition of how to actually calculate it. We could go back and back tested it to make sure that it makes sense. And two, if there's a case that comes in now, a new case that's uploaded by a firm today, the system goes through, the entire database of what we have, and likely out of the 5,000 cases, it's going to find something that resembles to a case you've previously worked on. So it's important to also note that the reports are not necessarily influenced by your previous decision. They're informed by it. It's an angle you took. It's a thought process. So it's almost like taking your expertise and consciousness of, develop what you developed over the last 4 decades and taking the best of that expert knowledge and putting into a database and making it work.
So you have the kind of knowledge-based framework overall, but the difference then is that expertise in looking at it and evaluating what you're getting in and turning it into this score. Now, how did you find it? I mean, we gave you all those cases, anonymized. How did it do once it was trained? Is it reasonable? Is it brilliant? Or is it no use at all? What was it
Yeah.
when you looked at say my thoughts on something and AI's thoughts? What was the correlation?
Perhaps I can talk about the white paper we just got done working on, if that's all right, and that probably answered the questions best. In order to make sure that we are on the right track and the system is independently accurate with no influences from us, what we've done is we took off the 5,000 plus cases that we have in our database through you, we took 1,000 random cases and we worked on a white paper. And the way it worked is we extracted your opinions or commentary about a particular case completely and it's expunged and checked by a third party that all we had to analyze was the actual facts of the case, medical reports, doctor's reports, etc., with no opinion from you at all. Those 1,000 cases were then ran through the Peyton AI system. And then what we looked at is that after those were run, it ended up in 3 different possible scenarios. Likely to succeed as a medical malpractice case, unlikely to succeed, or needs further information. So 3 buckets. We then took your commentary on all the 1,000 cases and put them in the 3 buckets, which is how usually I generally give your opinions to attorneys anyway, likely, unlikely, and needs further evidence. And then we did a correlation analysis, how they matched. So without even playing around with it in terms of the human in the loop element, the first pass was a 97.4% match, meaning out of 1,000 cases, 974 matched exactly to what you said as a professional to what our system said. The 26 cases, discordant cases, we looked at them one by one. And what we found is that they were actually clumped together in a natural pattern where there were, and maybe you can explain this a bit better than I can, but there were multiple instances of potential malpractice within a case. There were pre-existing conditions. They made it more complicated that the system wasn't able to initially grab. But the beauty of this, then we went around and then we got your opinion, which is how a proper custom LLM is supposed to work. We go back to the expert and asked for the opinion on why is discrepancy. You gave your feedback and explanation as a human in the loop element. We then reran the cases based on your input, and the result was a 100% match.
So what you're telling me is, as a medical expert, I'm not redundant yet.
You're pretty good.
I
You're pretty
mean,
good to say the least.
we still have to. I mean, we tell people they now need to go for their expert, and it tells them what expert they need and what field it is, because we've gone right across from NE to orthopedic to cardiology to GP to obstetrics and gynae. I mean, we've all those types of cases, which we've used the same system of thought in. So what is actually the difference between what we have produced as Peyton AI in the silo, if you like, and that horizontal of, say, ChatGPT, Claude, all those other ones? What is the difference that Peyton AI can offer that they do not?
General purpose LLMs are pretty good at predicting the next word in a sentence. That's how they're trained. They are trying to look for summarizations and predictions based on patterns that they've learned in the past. What they're not good at is thorough reasoning in complicated topics that are multi-aspect analyses required. So there's multiple variables. And there's also the nuances that that cannot be just predicted with text. This is where your expertise came in. So what we're doing now is we created a silo where if because of the way we structure the systems for Peyton AI, the disadvantages that can usually occur and cause a lot of trouble for law firms, as we know. We probably heard some law firms getting into trouble due to hallucinations, cases are made up, names are made up. What we've done from the beginning is that the system for Peyton AI is instructed to not look at anything else other than the actual case facts. That's it. Of the thousands of cases we ran so far, we've had 0 cases of hallucination. And that's by design. There are redundant measures in place where the system, once again, just only knows what we fed it. It knows the case facts as provided by the attorneys. And then it knows the case law, it knows the standard medical care. There's nothing else that comes in the system. So the lack of hallucination is a major factor. The other one is the compliance factors. A lot of these LLMs, like I was actually talking to Cloud because they have the Cloud legal tool to see, if how they work. And they said, well, you can't really use it for what you're attending for because it's not HIPAA compliant. We can't process, specific patient information attached analyses or DICOM files through the system because HIPAA compliant. Well, now what then? It's useless, basically. I think what LLMs are good at is helping you draft a document, summarize a document, perhaps. But when it comes to this multi-angled, multi-variable systems that we're dealing with, they're poor. They are not consistent. Once in a while, you're going to get a good response, but you cannot rely on it. If I was an attorney knowing what I know now, having ran thousands of cases through our system and reading all of them, I will be very nervous using any general LLM for anything I do that I submit to court.
Yeah, and HIPAA is the American, but then it's got GDPR. It's got all the others as well, hasn't it? In fact, you have to have an agent for GDPR and stuff, and Peyton AI has that. Is that correct?
Yes. Yes, we have
So it's
multiple.
sort of military grade security on it, the way it's translated, but it also has the compliance watertight.
Yes. Well, without it, we can't really function. It had to be military grade, as you said. We have multiple representatives in EU. We are headquartered in California. That's where I'm at. And but our clients are worldwide. So wherever we are operating and will be operating in the future, we make sure that we are 100% compliant because that's just the way we need to operate. So we have EU AI Act, EU Data Act, GDPR, UK GDPR, and then we have obviously HIPAA compliance in the US. These are done to levels of security that's probably not even necessary. We want above and beyond just to make sure to protect the data because it is sensitive. But the system is secure as you can get. So when an attorney comes in, it's actually a very easy interface. All they do is that they create an account, takes 2 minutes. They get all the case files that they have, which could be in a zip file or PDFs. They literally drop and upload to a system, press start processing, and let it do its thing. And our processing time, just to give you an idea, and this is going to improve over time as well, but we can process 1,000 pages in less than an hour. So if you have a 5,000 page document, give it 4 or 5 hours, you're going to get it. But most documents, we'll see most cases are a few hundred pages. We can be done in a few minutes. And at the end of that, you get this report called a case triage report that gives you everything you want to know. And we've done, through your help, of course, Rodney, a pilot study where we ran actual recent, very complicated cases with attorneys in our jurisdictions that we cover and got their feedback. And feedback was like, this is pretty good, like almost no notes. I think this is what we were just talking about it. So that's very encouraging. But the reason why it's there and it works, it worked that well from the beginning because it was designed with your input because you've seen thousands of these. You know what the attorneys need. So this is kind of another way we cheat as Peyton AI through your experience in these cases. We give the attorneys what they need and nothing more.
Yeah, and that's very important. So what we're saying is it is special to ARM. It's not generic, and it doesn't hallucinate because one of the big things and features that we insisted on was that when what a client says is taken on board to give a guidance along with what the solicitor said to give a guidance, but the AI does not hallucinate. It tells you what's missing, and it doesn't invent if it doesn't rely, shall we say, on what the client or the solicitor actually says. It looks for the evidence behind that, and it tells you whether the evidence is there or it's not there. And if
Mm.
it's not there, it tells you what's not there. It doesn't try to make you happy. It's not there to make you
Yes.
happy,
Yeah.
which most of these are. It's there to specifically point out the duty, breach, consequence, and the damages belonging to this case and what the evidence is for it. And you were very, very, very hot on making sure it did that.
Because initially, I think our biggest challenge was the case notes and the medical reports we get can be intertwined with opinions from the attorneys or even the families and the plaintiff themselves. So we had to figure out a way. This is probably initially that took us the most amount of time, that the system, 100% of the situations, does not look at all in of any of the opinions, any subjective statements from family or attorneys. It solely looks at the facts of the case, medical reports, black and white. That's it. After running again thousands of cases, I'm happy to say this has been completely eliminated, and the reports, hopefully, the attorneys here will give us a try and they can see themselves, is 100% based solely on the case facts. And as you mentioned too, what we do is when a case is ran, there are multiple sections to it. So on your dashboard, you'll have the full case report where you can just download a PDF if you like, and that's all you might need. In most of the cases, that might suffice. But if you like to deep dive, there are different tabs for each case that you run. One will show your detailed timeline. So if you want to know what is the sequence of events that led to this complaint at the end, you can see that in one tab. You can see all of the documents that are part of the analyses, and every page that we analyze, you'll see the confidence that we have in every page and the relevance of it. It can be 8,000 pages, it doesn't matter. And then you will have a different tab for the legal core analyses. This, the pillars, 4 pillars of medical negligence analyzed extreme detail. On top of that, we have a tool, chatbot, that we named Sidebar. Sidebar is pretty useful in that any questions you have beyond what you see on the report already, which is a lot of information, but if you want to know an angle, how do I write my first demand letter, for example? Just say, help me draft the demand letter, initial demand letter. It will just do it for you. And it will be done in a manner that is consistent with the legal language in that jurisdiction, utilizing the actual facts of the case. All you got to do is literally review it and then put your, signature on it, send it out if you want. Or you want to ask further details about more of the reasoning. What is my angle in this? Anything you can think of can be asked to Sidebar. And the idea here is to give the attorneys a tool to really thoroughly understand the case. On top of that, and you were touching base on this one too. So when we run a case, we do something called the gap analyses. And this is basically what other evidence can the attorneys get that can strengthen this case. And that part also took us a long time to nail it perfectly, but it was well worth the effort. And what that does is that it looks at every single data point, medical reports that are connected to the case, and it will actually identify any gaps in analyses. So let's say there was like a fracture that wasn't healed properly, right? In one of the cases I remember. But the case did not have the x-rays from the original hospital visit where the fracture was identified. So the system will easily say, yes, there's a case here, it appears, but you better go get the initial x-rays from the first hospital to strengthen the case. So we will tell you exactly what you need. We will tell you if you need a further expert witness report from a particular specialist. We'll tell you exactly what that specialist is and what they need to bring. You'll have a whole list of things that you'll need to get to strengthen case. But if a case is strong enough, you're going to have a small list of this, hopefully, and that will tell you based on the merit score, whether this is worth your time or not. And then you can determine whether it's actually worth your time to go get the missing evidence.
Yeah, that's very interesting because, again, we need to stress that 90% of the people walking have no case. Now, they've been hurt. They might believe they've been hurt, or they may have actually been hurt in some way. They haven't got the outcome they wanted. And a lot of times they actually go to the lawyer looking for a second medical opinion because they actually don't know. And sometimes doctors are the world's worst at communication. and they're looking for an opinion. And again, the AI will give them that opinion, and it'll actually tell them why it doesn't reach the level of negligence that would be supported in a court. So it
Mm.
helps the lawyer to understand and to explain to their client what is going on here. And I think that's very important, because the difference between a complication, which occurs in every surgery, isn't anything. And in fact, the standard is reasonableness. It's not perfection. It's reasonableness based against what is likely to happen in that state or that country. It's reasonableness, what a reasonable man can understand. And complications occur. And a complication isn't the same as negligence. There has to be, the standard is below, and there has to be actual damage caused by that. Not that you didn't like it, or that unfortunately something has happened which you're going to have to live with. It's whether or not that is due to a breach of standard that falls below what would be recognized. And I think that's very important to help a client understand the difference between a complication and negligence. And that's where a lot fail on causation.
Yes, and I think a tool like this can help the attorney communicate that situation to clients more effectively. That's another one of the uses. Because having gone through all of these cases, a lot of sad cases, there's a big, huge human element here that is hard to ignore. However, as you mentioned, law is the law. You can have a case where people were hurt, but the damage section maybe is a minimal damage. So even if there is actual negligence, there is actual damage. At the end, the damages are so minimal that it's simply not economically viable for the attorneys to pursue this. And that is important because then this professional's role, I think, here is that gently communicate and acknowledge the hurt that the plaintiff suffered, but also explain these are the facts of the case. It's simply not viable to pursue this case, and here's why. So our
So
report
it's
came out.
helping the lawyer risk mitigate, not right?
Correct.
It's
Correct.
helping the client understand, but it also is a very big risk mitigation for the lawyer, that they don't take on cases that have no chance. And then they can spend their time and their billable hours on cases which do have a good chance, which is about 1 in 10.
Yes, and that's if we can sum up what we're trying to do at Peyton AI, it's exactly that. Spend your time on cases that you have higher chances of winning and getting a settlement out. And that's based on looking at thousands of samples that we have, plus every other case that we have access to, pretty much any case that we can get our hands to. So it's this cumulative knowledge base that helps guide the attorneys to make better decisions, to figure out where to spend their time, really optimize the intake, and also improve the intake process. So when we look at these cases, you're looking at a 5 to 8,000 page report. How many days and weeks is going to take to go through this? And what are the guarantees that you're not going to miss anything as a human? They're going to catch every little thing there. You'll be able to, come up with a timeline. And I also have known, like, there are other tools that I think, the legal AI tools that help summarize cases. They're pretty good at summarizing it, but there's no actionable intelligence. So our difference here between other tools that are out there is here's a summary, and here's actual intelligence based on what you've
It's
came up with.
intelligent use of the information. It's not
Absolutely.
just getting the information, it's intelligent use by a medical expert brain and type of analysis of that information to give you the opinion. Because, I mean, there's a minefield here. I know a lot of lawyers think, well, I've seen it all before, especially senior ones.
Mhm.
And medicine is changing so quickly. I mean, medicine doubles about every year to year and a half. There's all different things, different drugs, different. And AI, two things it does. It doesn't get biased. But
Mhm.
like it or not, a medical expert, this is the way I do it. Or I like this person or something. There's a human element in bias, which
Yeah.
this AI cuts out. The
Yes.
second bias is in the lawyer. Now, lawyers, we agree, they are advocates for their client. I mean, they are. A
Mhm.
medical expert's an advocate for the court. There's a tension there. The AI stays down the middle, so the lawyer knows what's coming. But there are a couple of effects we got to think about here. One is a lawyer who thinks they know the medicine in the law, and they have to become civil medical practitioners, really, when they're running these cases. That's called the Dunning-Kruger effect. It's that they think they're brilliant at it and they don't realize that they don't know what they don't know. And if they're not humble enough to say, I need a steer, then once I get it, I can feel confident in what I'm doing. But I need to have that humility to get a steer before I start. And that's a Dunning-Kruger effect. And the other one works with some younger lawyers and sometimes the older ones. And that's called the imposter syndrome. All of us, everybody on this call will know there are times when we don't really feel we know everything we should know. And, maybe we're not doing our best. Maybe we're not, pushing forward enough. I just don't understand. And of course, that's going to be a bigger problem in the future. Our plaintiffs, our clients have AI, and they expect our lawyers to learn all this, the horizontal stuff. They expect them to know that. And there's so much of it that the clients are using it. So if the lawyers aren't using this gift, which is what it is, then maybe they're not doing their due diligence. Maybe they're not actually doing what they should do, using ethically and responsibility those tools that are available. But they've got to watch those two effects, the know-it-all effect of Dunning-Kruger and the imposter syndrome, which everybody feels from time to time. What am I doing here? Especially when it's coming into court, especially when cross-examination goes on. Which takes me to the last point, really. There's a thing called a simulation engine. Tell us about that.
So what we've done is, because we have such extensive information about the case itself, we thoroughly analyze it from every angle we can possibly think of. The idea was that, okay, what else can we do to help the attorneys here on either side of the aisle, really, to help strategize their moves about this particular case? In other words, practice your strategy of winning this case, either the most amount of settlement that you can get, or if you're going to go to court, how can you win the court case? As you know better than I do, only a small percentage of the cases worldwide in medical malpractice actually ends up going to case, single digits typically. A lot of them end up in settlement. So we created a simulation engine where once you run your case, you can head over to simulation engine. And the idea here is that you simulate the next steps of your action based on the case facts that Peyton AI system already knows. You start the simulation. You can even pick the agreeableness degree of both attorneys. It starts out as default based on what we see from a reasonable attorney practicing medical malpractice in that jurisdiction, but you can make them less agreeable if you want to challenge. You can make it more agreeable if you want easier. But let's just say you go with the default, you start the engine. It will start out by generating your first demand letter, if you're the plaintiff's attorney, to the defendant's attorney. Knowing the case facts, it will write a very detailed opening demand letter. And then what happens is, based on the demand letter that you generated, it will also predict what a reasonable and prudent and a successful defense attorney, given the facts of the case and your letter, will say back to you, to your initial demand letter. And this can go on and on and on until you reach the point of either a settlement. It goes to a settlement meeting. You can negotiate the amounts. Then the amounts that are suggested in the settlement negotiation stage are based on real figures, most recent figures in that jurisdiction for cases like the one you're dealing with.
Right. So in fact, what you can do is use the sidebar as well. As you get these replies from either side, you can sidebar them in, and it's giving the AI more information to help you decide. So it's very powerful to do that. And especially with ADR coming in, alternative dispute resolution, that negotiations can be cleaner because you know what's going on either side. You know what anybody else is going to say. And for cross-examination, if it goes to court, which actually very few do. So that's an important lesson that we can look at this. So does that mean that the attorney or the expert is going to be replaced by AI?
Not at all. Not at all. This is basically a tool that just makes their life easier. It enables them to make better decisions. It helps them focus on cases that have higher chances of winning. It's an optimization tool. That's all it is.
So they're responsible until we have AI courts and AI juries. We've got people, and it's about the relationships they make. And that's very important, our lawyers' communication skills. It's about making strategies I mean, and deciding in a particular case what strategy should be used, because AI can be very cold. And we're
Yes.
dealing with people here, different age groups. There's a different context that's going on at the time. Maybe it was during COVID, maybe it was something else, but AI won't pick that up as much as a lawyer. The lawyers, relationships, their context, and their judgment is what's important here. And with the medical expert, it's the same. Medical experts will be able to look at this. They will have warnings, if you like, about when they're straying off the line, but they know their medicine. They have been in court before and they know what's going on. And what this is an adjunct to what they're doing. It does not replace them, but it's an adjunct. And that has been so powerful, Jesse. When we met, we just really didn't know what the art of the possible was. But your foresight and your insight, I am so grateful for, because that is what fired me up and said, we can do this, because, the trust was there. You've done it in the car industry. You have revolutionized the car industry. All they need to do is check that up, and there's another big one coming down the line. And you have done that so many times, so successfully. And to have turned your mind to something like this is just amazing. And I'm just so grateful that you and I have had this chance to work together to produce something which is global in its outreach and will be for justice. It's for the benefit of the client. It's for the benefit of the attorney. It's the benefit of the system. Because I saw something very, very recently from the UK government. They're finding the courts are getting screwed up. They're getting tight because of the amount of stuff that's coming through. And the UK government have said we have got to increase our use of AI in the law. That is declared. And this is one of the ways it's going. So how do people get in touch with us, Jesse? I mean, if this has sparked them up, how do they get in touch with us?
Well, first of all, thank you for the comments. It's been my pleasure. This is kind of a dream come true for me to bring a medical field and law in together and come up with a solution and work with somebody like yourself. And you were working all hours of the day, as you know, and it's always been a pleasure for me to spend this. And we're just at the beginning of the journey. Well, we built something incredible. I think we're already starting seeing impact. One thing I can add, there's a big human element for me too. When I started working on this project, I looked at it not from the plaintiff side, on the defendant side as well. And just in the US, there are, as far as I know, dozens of medical doctors that actually end up, in very stressful situations up to, perhaps ending their life, that kind of a stress because they're being sued. So we want to create this truth engine in medical negligence where no matter where you are on the, in terms of the ecosystem of medical negligence, you can have a system that you can rely on that can protect you and that can guide you. That's really what we're trying to create. This isn't an engine to, enable plaintiff attorneys to milk more money and from the system, etc. It does help them pick the good ones so they don't waste their time on the bad ones or the ones that have no potential outcome for them. But it's really meant for both sides. It's also meant for educating upcoming attorneys. Hopefully, we're going to be working with a lot of law schools. And also, one thing to add on simulation engine, like it does a settlement, but it can also do a whole virtual courtroom simulation with the cross-examining of the witnesses and everything you can think of. But that actually abides the rules and the customs of that particular jurisdiction you operate in. So it's kind of fascinating to play around with it.
It's
But
totally fascinating. And I'm going to
yeah,
pick on one phrase you used
sure.
there. It's the truth engine. I think that is probably the most powerful thing we've said. This is the truth engine. Bias is out of it. It looks at facts, and AI can gather facts which the human brain cannot do. It just can't hold that amount of fact. And it can analyze it. And it has taken an expert's kind of strategy for analyzing it and put it into real practice. The truth engine. Jesse, thank you so much for joining us today.
My pleasure. Thank you.